Friday at noon, and welcome to the consultation. My name is Christina Jimenez.
And I am Josh Floyd.
And every Friday at noon, we come together to talk about complex legal issues pertaining to family law. We sprinkle in a little bit of criminal defense because sometimes in the context of family law, we also have criminal issues that come up. We have a podcast, so check us out there. We have YouTube, we have Facebook Live, it's on our website. You can, if you want to watch these videos, you can most certainly find them. I do tell people at the onset of this event, in the beginning, middle, and end, do not take this as legal advice. And the reason why it is so important that you guys don't do that is because, and you'll notice as we're talking through these questions, one little thing, one little fact can change our entire opinion about what we think a judge is going to do or what we think we should do. So it is so important that if you find yourself in a situation where you have a complex family law issue or any family law issue for that matter, that you go and you consult with an attorney who knows what they're doing in family law and you follow their advice. Our hope is to kind of give people a little bit of nuggets here and there so that you all can take that information and maybe discuss it with counsel of your choosing, and just to hopefully, provide a little bit of hope in the world when, people are going through this. It's never fun. So hopefully we can kind of give a little bit of a guidance as far as, having some hope and some being able to co-parent a little bit better with the other spouse. So with that being said, Floyd, you want to ask the first question?
Sure. Can I keep my daughter away from her mother if she no longer wants to be there or wants to go back? Me and the mother of my child have been separated for some time now. We were not married or anything like that, and we're not dealing with the courts or anything like that as well. My daughter just lives with her, and now she wants to come live with me for the remainder of her life. Good luck, buddy. And the mother of my child does not want that to happen. What do I do? My daughter is 12 and will be 13 in May.
Okay, so separated, not married, not dealing with the courts. Daughter lives with her. Now she wants to come live with me. So it doesn't appear as though they ever filed an original suit affecting parent-child relationship. So whenever we always have to give a backstory, and so hopefully, or like kind of just explain the basics of how this stuff normally goes down. So typically when parents are separated, you're supposed to, or most people will go and do a suit affecting parent-child relationship. Okay, you don't have to. And I guess it might be good if they have been able to get along for this long without a court order.
No.
Why not?
That's a terrible plan.
But they've been co-parenting. They've been doing well.
Until she gets a new boyfriend that doesn't like dad, and then they move to Nebraska and sue him for 4 years of retroactive support.
Golly, Floyd. I thought we wanted people to just be kind to one another.
Well, that's what we want. That's certainly what we want.
Golly, you're such a grump today. You're so grumpy. Be prepared, everyone that's watching. He's a grump today. Okay, so I was thinking from the context of if you guys can get along without a court order and things are going smoothly, then I think that's kind of cool. But I guess if we're going to take the pessimistic view of mom taking off with the child to Nebraska, Floyd's right. We should have, or you should try to get a court order when you all separate. In this particular case, obviously, I would say that things are probably going to take a turn for the worse pretty quickly, because now kiddo wants to go with dad and mom doesn't seem like she's going to agree to it. And so what dad is going to now have to file is a suit affecting parent-child relationship. That's how we start off these custody cases. Okay. And so basically what he would do is request a temporary hearing. He probably requests that the court confer with the child because she is 12 years of age or older. She gets to go back and talk to the judge in chambers, and she can tell the court, I want to live with my dad, and this is, why I want to live with him. I will say, for the most part, all things being equal, if mom and dad are both decent parents, kiddo loves both of them, but just has a preference for whatever reason, 9 times out of 10, judge is probably going to let the child go and live with dad. This whole statement of for the rest of my life is not realistic. I mean, it's anytime you go to court on a custody dispute, the court will render a final order, but that final order is always going to be subject to future modification. Okay, so if dad, gets into any trouble, or kiddo decides, I want to go live with my mom now, I hate living with my dad, or I don't know what else could potentially happen. What else could happen? Hell if I know. There's all sorts of things that could happen. But if for whatever reason in the future, mom decides she wants to take dad back to court to fight for custody, she's going to have the ability to do so. And dad's going to have to probably lawyer up then to fight it. So I guess because kiddo's 12 years of age or older, she gets to go in and talk to the judge. Typically what will happen though is before that happens, the judge is going to want to hear evidence from both sides, right? And a lot of things, I mean, if your mom's attorney, you're probably going to go in and you're going to say, well, she's been with me this entire time and I've been providing support and I know about her doctors and her schooling, and maybe dad's not that active. And dad doesn't always show up when he's supposed to for his visits, etc. Right. And then on the flip side, dad's going to come in and say, no, I know that all the doctors and the schools, and I see her all the time, and I have this great home and whatever. Judge hears both sides of the story, and then from there talks to the kiddo. And again, all things being equal, I think dad probably wins. Have you ever had a case where kiddo is 12 years of older and we didn't get custody after conferring with court?
No, not to me, but I've had it happen to attorneys that I was against.
And so I can think of a couple of instances. I'm trying to think of examples of when the judge would kind of disregard what kiddo says.
So if the child's having mental issues, if they're going through a lot emotionally, suicidal ideations, drug use, things like that, the judge will listen to them, right? Try to get them help and things like that. But as far as letting them choose where they want to live, I don't think they put a lot of veracity into that.
Okay. I had a case where there was allegations that one of the parents was an alcoholic, and there was enough evidence that was presented that the judge said, yeah, I don't feel comfortable letting the kiddo go and live with that parent because of that. And so a lot of people have this perception of, well, kiddo is 12 years of age, so they get to designate, and that's the extent of it. There's always going to be what we call a best interest component to that decision. And so the court can take all things into consideration and say, best interest, I believe that it's not good for this kiddo because of schooling, mental health, drugs, alcohol, having to relocate. Like there's all sorts of crap that the judge can take into consideration and say, I get it, that's where the kid wants to be, but I'm not going to do it.
Well, so also if the judge can tell that the child wants to go live there because that's the fun parent, right? Maybe not the most responsible parent, but the fun parent, mom lets me get away with whatever I want. I don't have a curfew. She lets me shoot up heroin, whatever it is that this kid wants to do. And the child wants to move because he's living with the disciplinary parent. I think the judge would take that into consideration when making that decision.
Right.
But in this case, though, so I think what I would do is I don't think I would want a court order.
What the hell are you doing? You're an idiot.
No, what? But seriously though, off the bat, the strategic move might be to let child stay there as long as she can, talk to mom, see if she can stay just a little bit, get a little bit of that time of child living with dad getting more involved before you file the SAPSR. And then if mom says no or causes a big ruckus or whatever, then you have to file a SAPSR, right? But I would think we want to try buy as much time as we can with child living there before we filed.
Yeah, when I read it, I didn't think that mom was going to allow that to happen because she's like not having it, right? So if you could do that, or if he could somehow do that, I definitely think that would help, but I don't think that that's going to happen. I think the only way kiddo goes to live with dad is if he files a motion. Now, you brought up something super interesting or important, I guess, and that's the idea of retroactive support. So why don't you speak on that?
So retroactive support is support you have to pay retroactively. So if, like in this case, or like Christina suggested, you just don't have an order and mom can establish that the child has been living with her and dad has not been paying child support, what mom could do is file a SAPSR and request retroactive support. So to make dad pay her for all the child support that he didn't pay her. The presumption is they can go back 4 years, right? And so even at minimum wage, right, if you're looking at 4 years, that's about $10,000 in child support arrears where he starts off the bat just because he didn't have an order in place and wasn't paying child support. So that's the danger of not having an order. Now, maybe if it's a great co-parenting relationship and he's Venmoing her child support and we can prove that, but it's just so, I don't ever advise it. I think it's scary because they all get along until new boyfriend, new girlfriend, right? And then shit hits the fan. And then you start playing this game with the child of, I'm taking the child here, I'm taking the child there, and then Nebraska.
So, I have had it happen before where the courts didn't order retro support, even if there wasn't a prior order. And the idea or the, I guess, rulings that we were given or findings that we were given is that mom never filed anything. Like she could have filed something like 10, 12 years ago and she didn't. And so they weren't going to put dad in the hole because mom was choosing or has chosen to not do that, right? And so they're not going to get a 40, 50, $20,000 judgment against dad because mom just chose to not go to court because they were working together. But if you're in that sort of a situation where you don't have an order and for whatever reason you guys just don't want to do an order, then make sure, like Floyd's saying, but keep track of the payments that you're giving her, because typically what we would do in that situation is I would go through and I would say, okay, for 17, his child support should have been X number of dollars, right? Because I'm looking at his tax returns there. And then 18, same thing, 19, 20, whatever. We do a big spreadsheet of here's what he should have paid pursuant to the guidelines. And here is what he actually paid. And obviously, depending on who we're representing, we try to get that judgment as low or as high as we possibly can. Now, keep in mind that the presumption is 4 years, but I've had courts actually go back 14 years, depending on the situation, and get really, really significant judgments against some of these parents. Typically when that happened, though, it was like really crazy and bad circumstances that in those cases the fathers have put themselves in. But it's an issue. It is an issue. And so I hate to freaking say it, but I guess you are right.
This is being recorded, right?
No, we're gonna edit that little clip out. It is smart. And so I guess the other thing is keep in mind, even if you guys get an order in place, you don't necessarily have to follow it. Okay, so whenever there is a suit affecting parent-child relationship, at the top of the possession schedule, there's literally a phrase that says absent mutual agreement. And so what that means is if you guys can agree to do something other than what is in the order, then do it, right? If it works better for you guys to do a week on, week off, a 2-2-3, whatever, do that. What this order is for is if you guys can't get along and you can't agree, then we default to the order, right? And so that may be the best thing to protect you, especially when it comes to the support issue, because that, or a relocation issue. So what else would, I guess if they get a judgment for the retro support, and that's a risk. When he files the SAPSR, I mean, that's what we would do, is we file a counter petition, and then we'd request retro support and current child support, and medical support. Oh my gosh. I'm gonna delete that comment too. We have the ability to redact comments as well, so, and medical support and uninsured medical expenses. And so if you're gonna make this move, Dad, you better make damn sure that kiddo isn't gonna change her mind.
Yep. And then on the judgment, right, we have 6% interest. Right. So it'd be very expensive.
Yeah. And so, you know, the other thing is if they get this judgment against you, you're going to potentially have liens put on your tax return. They'll garnish additional wages. It can affect your driver's license.
They do that for liens or just arrears?
Well, that's what I'm saying. It's an arrears judgment.
Well, so yeah. So if a judgment is confirmed, right, then they would take all of that enforcement action based on that judgment. I thought that was just if you were in arrears with a current order. No, they do it based on a judgment. I don't know why I thought that.
Yeah, I mean, if there's a judgment that is rendered against you and you owe like 20 grand, then absolutely they have the ability to garnish your child support. They have the ability to put liens on insurance checks. Like if you get in a car accident, they can put a lien on that. And they don't even need the judgment. If you're in arrears, you're in arrears. But yeah, they can really screw you over. And so, and that's why a lot of these judges are like, listen, Mom, you didn't try to come and get an order 10 years ago. I'm not going to put all of that on him. You should have done something sooner. And we're starting clean from this point forward. So what about this idea of having kiddos talk to judges? What do you think about that?
Like personally or legally?
Either. I don't care.
You just want to talk about kids talking to judges? Okay. Some judges like it. Some judges don't. Sometimes it's beneficial. Sometimes it's not. Yeah, I think it's definitely a strategic move, right? You've got to know the judge and what their inclinations are. There's some judges that, I mean, absent a sex offender living in the house, if the child wants to go live there, the child's going to go live there. And there are some judges that have publicly said they don't talk to kids about that. Whenever the child goes back to chambers, they talk to them about football or whatever else. They don't ask them where they want to go live. That's not a position a 12-year-old should be put in. So definitely got to know your judge to determine how much leverage the child wanting to come live with you actually gives you, and whether that's the right strategic move or not. But and I think that it depends on the child too, whether it's good for the child. Generally speaking, I would say no, right? You don't want to put a child in the middle of that, having to choose between mom and dad. That's never good for the child. But if that's the only way to get them out of an unsafe or unhappy environment, right? It's the only thing you can do.
Yeah, I agree. I try to avoid those conversations if we can. I just feel like it's a lot of pressure, and inevitably, like, the kid is always going to feel bad about what they say. Like, and it doesn't matter if they actually get what they want, they're always going to feel bad, and there's always going to be this resentment, between the kiddo and whatever parents they didn't choose, right? So I've really tried to, especially, here more recently, I've tried to avoid putting the child in that situation. And really, the way that I've tried to do it is just talking to the other attorney and saying, listen, I know that your lady knows that this is where this kiddo wants to go. So can we try to not put that child in that situation? And I've had some attorneys that are like, no, my client will not agree. The kiddo is going to have to talk to the judge, because I think they're hoping that, child will change their mind or won't, confirm it. And I've had others, and I've done it too, where I tell my client, like, listen, I know this judge, I know what's going to happen. I really don't know that we should put the child in this situation. And then at that point, it's a parent situation or a parent decision. So keep it in mind, especially if you're the parent that the child doesn't want to live with. Let's think about the mental health component of making them go through all of that. And try to keep all the litigation and all that crap away from her as much as possible, because it's
For him.
For him, yes. Because it's just heavy. Okay.
Yeah, and I would say that I'm not confident that what the child tells the judge is what the child actually wants, right? Frequently, the child will say something different than what they tell our client, right? The child may be saying, yeah, I want to come live with you, Dad, I want to come live with you. And then when they get back to the judge, they start feeling bad. And it's like, oh, I don't care where I live. I'm happy at both homes, right? And so judge doesn't move them, right? And you've put them in the position to have to feel like that because they don't want to choose.
Right.
So you put them on blast.
Right. Yeah. And I've definitely had those situations come up several times where, my client was adamant that the child felt a specific way, and that's what they were going to say, and that's what was going to happen. And then, and I don't know if it's the judge, I don't know if it's the kiddo, I don't know, because when they go back and talk to the judge, parents are parents are never there. The attorneys can be there, but I've never had a conference with a court that would allow attorneys to be there. It is the judge and the child and the court reporter most often. And even if the court reporter's there, they're not even taking a record. They're just kind of there as kind of a witness to the conversation. But it's completely private. And some judges just come out and they tell you, based on my conversation with the child, I'm not modifying, right? Or based on the conversation, I'm going to go ahead and allow the child to go to the other house. Other judges will give you, a lot of information and say, this is how your child is feeling, and so you need to work on this. It kind of just depends. And that's why Floyd says biggest thing is to know your audience, because that it can make or break you in these types of cases. So
shizzle.
That's why I said make damn sure that this is what she really, really wants, because otherwise you're opening up a can of worms. So Floyd.
That's two.
I was waiting for that. Okay, I'll read the next question. Legal advice and who can claim children on income tax? Hi, I'm trying to get information on the final divorce decree. In the decree, it states wife is responsible for car debt. Husband was co-signer. Bank stated wife never went and got it solely in her name. The wife let the car get repossessed after she bought a new car. Now it is on husband's credit report. How would we go about this and getting it taken off? And who is eligible to claim child on income tax if it's joint custody and mom has primary?
That's kind of like a started off with tax return, went down car debt into a tax return, right?
Right.
Cool. So we could talk for 3 hours about this. Let's start with tax return, right? Because that's pretty easy. We don't know the answer to it, right? So what I tell my clients is I'm not a tax attorney. I'm not a CPA. I know how to add really good with Excel. So they need to seek the advice of a tax attorney or a CPA. However, what I have been told is
You're such a lawyer, dude. Go
they
ahead.
report me to the bar for bad advice. Is primary claims the children, right? That's the general rule. I don't know if there's exceptions to that. I don't think that there are, but I don't know because I don't handle tax law. But so generally speaking, primary claims the children. Sometimes you can negotiate to where it splits up. That kind of. Did you have a question, Ms. Jimenez?
I actually had a comment because I don't know that it's just primary. It's my understanding, and again, I am not a tax attorney.
But based on what you've heard,
Based on what I have also heard, it is based on where the child has resided for 6 months or more, the primary residence for 6 months or more. And so it starts to get really tricky when you're doing like a 50-50 possession schedule. And normally, Floyd, what do?
you split the kids, not physically on tax returns. So like you'll alternate years, or if there's two kids and one claims one claims the other. Yeah, that's typically what you do on a 50-50 possession. But on the tax return issue, the reason I say generally primary, because most of the time primary has the child more than 50% of the time. But I think you're right. I think that is the rule, that it's whoever had the child more that year. But I think that if the decree named one person primary, it would be an uphill battle to try to prove the IRS that you had more than 50% of the time. So generally that's the rule, but go see a good tax guy.
So we can also, though, Floyd, incorporate that language that says that mom gets to claim in these years and dad gets to claim in those years, et cetera, right? So we'll do that sometimes. I am fairly certain that language is enforceable because it has ordered language, and it's like mom must not do this and mom must do that, or is ordered to do this in order to do that. So I think you're fine. And if that is a concern to you, then make sure that you're incorporating that in your order. I will say, if I'm representing the primary, I never agree to give up that right. I've had, people ask for that, like the dads ask for that if they get visitation. Most of the attorneys will say no, like there's no basis for that, unless we're getting something in exchange. What about when somebody claims the child on taxes and they're not supposed to because they haven't had them?
That's great, because I was just about to go into that. So we'll talk about it from two different perspectives, because I was going to go a different route, but we can go this route and then I'll come back around.
Okay, good.
Okay. So the non-custodial parent claims the child on tax return. Is that your question? Okay. Then the custodial parent has to manually file the tax return to claim the child. And then the IRS gets to come in and sort it out. Who had the right to claim the child, et cetera, when they determine that the primary parent, custodial parent, should have claimed the child or did have the right to claim the child, and the non-custodial parent shouldn't have, and therefore got an improper credit, the non-custodial parent gets to pay back the IRS.
Excellent.
So the route I was going to go with it is when you were talking about enforceability. Whenever that is in an order, you have to understand that this is a state court signing the order, right? And the IRS code is federal. And so the state court district judge can't tell the federal courts or agencies, this is what I said, right? So they're going to tell, if you tell them the IRS what's in the order, they're going to say, I don't really care. This is what my law says. This is what we have to follow. So even though it's in the order that dad claims in odd years, if mom claims in odd years, and it's pursuant to the statutes in the IRS code, she's going to get the credit, right? You can't force the IRS because of your order to allow you to claim the child. What your remedy is what Christine was talking about earlier, file an enforcement in the district court for violating the order, and then seek some jail time and run up attorney's fees and really hang her out to dry, then take primary, and then you get every year claiming child tax credit.
So the other thing is if you try to have a contested hearing on that, so, if you try to go to the district judge and say, Judge, I want to have the right to claim the child because I make X number of dollars, or she has, 3 other children, the district judge is going to tell you to go fly a kite. They're going to say, that's not my jurisdiction. I'm not messing with it. And then
I thought maybe the judge just has a kite hobby and that's what they were going to do.
They just tell them 3.
But these are such a can of worms, fly a kite. Come on. Those are, my 4-year-old knows those.
Oh, she's a very smart 4-year-old.
That's who her daddy is.
Lord. Okay, next. Car debt.
Next part of the question. Car debt. Tough titty, said the kitty. But the milk is still.
If Facebook is going to bleep that.
Let's see. It shouldn't.
It didn't. It didn't.
Yeah, because I don't say bad words on Facebook Live. So this is a problem when you have debts, joint debts when you get divorced. And it's more of a problem when you don't have an attorney that will take care of it when you're divorced, right? So what you can do about it now? Nothing, right? Pay the debt. The reason is because the creditor looked at both of your credit and to hold both of you liable for this debt. And again, the judge can't force the creditor to only look at one person's credit, right? And so it's joint debt. She didn't pay it. You got to pay it. It's going to hurt you both. It is what it is. However, it could have been cured. Unfortunately for you, it wasn't. I think probably because you didn't listen to our podcast or didn't pay attention to when Christina said, hire an experienced attorney that knows what they're doing. Because an experienced attorney that knew what they were doing would not have allowed that shit to happen.
I thought you didn't curse on Facebook Live.
Shit's not a bad word, watch.
It is a bad word.
Shit, it is a bad word.
With it played, yes. Oh.
Okay, so an experienced attorney would have ordered that she refinance the debt to be solely in her name or sell it and then pay off the debt. Generally, we'll give them, 30 days or 45 days to refinance a car, order her to make payments. If she misses a payment, you have the right to then go in and repossess it and place it for sale yourself, just to make sure that we could stop this from happening, right? To try to protect your credit as much as possible. Credit takes enough of a hit during a divorce. So any way that we can try to stop that, it's helpful. And this is one way, right? I mean, if you got a joint debt, it's got to go to somebody's name. Language has to be in the order to enforce that and to give you a remedy if they don't comply. But that wasn't done.
Yeah, I'll typically, if there's any possible way to, if the other side's vehicle is in your name, I try to figure out a way to get that vehicle in my client's control, to sell it immediately. There's been times where we've even purchased the vehicle from the other side, bought out their equity just because and especially, my clients who need really good credit because they're business owners or whatever, try to get it out from underneath this person, because, we've given down payments, to help the other side get their new vehicle. We've done the trade-in paperwork for them, just to get it out of your, because otherwise it's potential disaster. So, but yeah, that's that. And I'll tell you also, guys, sometimes if there's not a way to do that, right? If there's no money and you don't want to pay, you don't want to buy it, you don't, whatever, and y'all go to court, the judge is going to say she needs a car, right? She needs a car, you need a car. I understand that it's financed in your name, but 9 times out of 10, judge is gonna let her keep that vehicle. Even if it's in his name. Yes, sir. No other options? No other
I mean, I
vehicle?
guess no other options, right? I mean, there's no other property that can be used to pay that debt off and count as a division. I guess no other options. Yeah, I mean, and I've had guys that, are nice guys like myself, and they they don't want to force that. They just want to let her keep the vehicle. She'll pay for it. I trust her. And I try to tell them, bad idea. But they insist on it, so I let them do it. And I'll just tell them, hey, I'll see you in a couple of years. Come back and hire me whenever they screw you over. And I'll tell you that there's nothing I can do because you didn't listen to me the first time. But I'll still take your money to do it. So.
Oh my goodness. Okay, what else, Floyd? Anything else on?
I think that's enough on tax debt and car notes.
Yeah. Okay. Your turn to ask the question.
Is it possible to remove a geographical restriction if X works out of the country where child lives? Okay, gotcha. And only returns home on weekends. Can my geographic restriction be lifted?
It depends.
Yes or no? No.
It depends. So.
Oh, look, my word was so bad that Sarabia wouldn't type it.
Oh. So yeah, it depends on what your order says. Most of the time, the standard language on geographic restrictions is you are restricted to that area so long as the father primarily resides in that area. So if he's still there, you can't move. There's typically language that says that if he ever relocates outside of that area, at the time that, if he's not living in that area at the time that you want to move outside of that area, then you'll be able to do so. The geo's lifted, right? So make sure you got to go and talk to an attorney and show them your order. Now, if for whatever reason that language isn't in there, I definitely think that, there's a good chance that if you go to the court and say, hey, he's living in or working in whatever country and only flies home during the weekends, I think there's a high chance that judge would probably allow you to move, but it depends, right? It depends on, does dad have other family in Bexar County? Does he, have a home there in Bexar County? Is that still technically considered his primary residence? Is he only working out of country temporarily? Like, there's a lot of other factors or questions that I would want to know before I could say, yeah, you're going to be able to move, because it's not that simple.
It's not. Yeah. I mean, and that's what I wrote down, right? Like, where does he reside? That's the question. If he's working out of the country, in order for it to be his residence, I believe it's got to be intended to be permanent, right? And so if he's still living in Bexar County and he just works during the week and comes home on the weekends, then that provision you were talking about wouldn't save him, right? Because he's still residing in Bexar County. But now if he moved to Bolivia and he's just comes in to visit every weekend, maybe it just, I think it depends on the relationship that he has with the child. It depends on whether he would still be able to see the child or how all that would work, the logistics of it. Court's going to make sure that he keeps that relationship with the child. That's what's going to happen. That's the purpose of the geographical restriction. And so if they think it'll interfere with the relationship, you're not going to get it.
Well, and I would even say, like, even if that provision of if dad's not living in the area, the geo's lifted, I probably wouldn't be comfortable making that move unless we went to court. Because
in this situation?
Yeah. Because if he's just working and only returns on the weekends, and let's say, hypothetically speaking, he does have the house there in San Antonio, and he has his wife and his children living in San Antonio, and our client doesn't know how long he's going to be working in Bolivia and all of that stuff, I wouldn't feel comfortable saying, all right, yeah, go and move up to New York City, without the judge hearing all of this and then making a determination, because you don't know if it's not his primary residence anymore.
Well, first, nobody wants to move to New York. She would move to Nebraska. Yeah, and it's very fact intensive, right? Under the circumstances you said, yes, I agree. I mean, I think there's more facts to show that his relocation to Bolivia is temporary and not permanent, so he still resides in Bexar County. But if the facts were reversed and his family was in Bolivia, but he still came in every weekend, I would be comfortable saying go to Nebraska. Because I think if it's reasonable, I think worst day in court, they file an enforcement and it's not clear, right? I mean, you have an argument, and by then you're already in Nebraska, rooting on Cornhuskers, you're good.
Yeah, that's scary. And I will say, like, anytime relocating outside a geographic area comes up, I'm very, very worried. I want to make sure that we're doing the right thing and we've dotted all of our I's and crossed all of our T's. So that way I don't find my client in a situation where she loses custody, because that can happen. And we've seen it happen where mom, just gets up and relocates to New York City, in my hypothetical.
Maybe in New York City, they would lose custody, but Nebraska, judging.
And when they move to New York City against the geographic restriction, judge says, okay, well, now kiddo's going to go and live with dad because you didn't follow the order. So be very, very careful, and make sure you hire a good lawyer on that. So
whenever somebody wants to modify the geographical restriction, I ask generally two questions. What do you have against them that we can use as leverage? And if that's nothing, what are you willing to give up to move? Because that's the only way you're going to get it.
Yeah.
Either force them into it or bribe them.
And I can't, this is probably like one of the most frustrating topics of conversation that we have with the primary conservator, is why is the court limiting me? Like, why can't I move wherever I want to go? And the response is it's not a limitation on you, it's a limitation on your child, right? It doesn't say you can't live anywhere else. It says your kiddo has to live in this area. So you can go to freaking Nebraska if you want to. I would go to New York City, but your kiddo has to stay here. And we've had situations where, client gets remarried and her husband has a great position in California, her new husband. And we try to get that geo lifted so that they have a new kid, another kid together, to let that kiddo go. No luck. Had a situation where the mother was going to be making like 3 or 4 times her income, and she wanted to move to another state. Not going to happen. It's just, like Floyd said, you got to give something up, or you have to get some sort of leverage. And even then, judges are not inclined to do it.
Yeah. And I'll go back to it depends on the judge, right? Because I'm sure there's some people listening thinking, oh, bull crap, I got mine changed because I got a raise and got a new opportunity. Some judges will let you. Most of them, no.
Yeah.
But there are the exceptions. The judges don't care about the kids. And
so what I would say is, so if this is a concern to you, like let's say you're the primary conservator and you're just going to court, then a lot of times I will try to not include a geographic restriction. And again, if the other attorney that I'm dealing with is not experienced, then sometimes I can get that to go through, right? And that's, their mistake or their client's mistake, not ours. Or I will expand the geo to, let's say hypothetically speaking that my client says, well, there's a chance that I might want to live in Houston in a couple of years. I'll say, okay, well, why don't we limit this to Denton County and what's Houston again? Harris County. Thank you. And so let's see if we can limit it to those 2 geographic areas, or let's see if we can limit it to Texas, just trying to plan ahead. So try to do that if you can. It depends on the other attorney and the other side. Some of them are going to say, hell no, we're not going to do it.
Yeah, I think the issue is the primary conservator's primary concern should be the child, right? Not whether they need another husband or they need a spouse in their life or whatever, right? I mean, just can't hurt the child to get what you want. So don't do it. If your primary concern is not the child, you don't need to be the primary conservator.
But Floyd, that is subjective. And I understand your position. It is. Floyd's position is that geographic restrictions should always be imposed because the child should always be able to have close and continuous contact with their father. No?
I'll go a bit further and say that's not only my position, that's public policy of the state of Texas, but go ahead.
But it's not that simple. If dad's a drug addict, if dad is an exercising visitation, if dad has, a history of family violence, then there are exceptions to this. And if mom has to go and live with another family member because otherwise they're going to be homeless and father's not paying child support, there's reasons why sometimes a geographic restriction should not be imposed.
Well, no, I agree. And all that stuff is taken up on modification, where all those really fact intensive things we were talking about. The overarching theme here is the court's going to allow the child and the father or mother, whoever it is, the non-custodial parent, to have a relationship if they want one, and not going to let the custodial parent interfere with that by moving. But if the non-custodial parent chooses not to have that relationship, doesn't come around, doesn't pay child support, then I don't think the judge will really give two hoops about letting the child move.
So real quick though, that you said doesn't come around, doesn't pay child support. Just because dad's not paying child support, that's not going to be enough to be able to move geos.
Might be.
I don't think so. That alone, if dad's visiting consistently.
Yeah. So what about the argument of, I'm a stay-at-home mom, I'm married. My spouse got a job offer that would allow me to support the child. Dad hasn't been contributing. The only way we could feed the kid and clothe the kid is if we get a raise. If dad were contributing, but he's not.
I mean, it's worth the try depending on, the case, but I don't think judge does it. I think judges are going to say, dad, you need to start paying child support, but he goes to the school and eats lunch with the kiddo every day and is the t-ball coach. And
well, he won't be doing that for 6 months or he'll let me move.
That's a true statement. Yeah. So, what else on Geo? Is that it?
In case our audience didn't get that reference, he will go to jail for 6 months for not paying child support. That's why he won't be seeing the kid.
Holy Floyd. You're so grumpy today.
One of those days. Hang them dry. Let's go.
It's one of those days. Man. Okay. Your question or mine?
You ask.
Okay. Oh gosh, we only have 6 minutes. If my husband and I are considered common law married, what could I do to legally protect my assets?
Not be common law married. So a lot of people misunderstand the common law marriage, right? And they think that they're married because they've been living together for 5 years or whatever, 6 months. I hear a lot, if you don't satisfy the elements for common law marriage, it doesn't matter how long you live together, right? I mean, in order to be married, you have to hold out to others as being married, represent to the general public, introduce as friends, things like that. You have to have an agreement to be married, and you have to reside together. There's no minimum amount of time to reside together. You can reside together for 2 days. As long as you accomplish those other 2 elements in that 2-day window, then you're married. So just because you've lived together for 5 years doesn't mean you're common law married. So I would make sure that you're in fact common law married. I would seek a great attorney that maybe has dealt with this issue before to find out whether you're common law married. If you are in fact common law married, your assets are community property.
I thought you were going to say your assets are grass. No.
No, I like to say funny
Yeah.
things.
Is grass, get it? No?
No, I got it, right?
That's reference.
But her assets are community property.
Well, that's why they're grass, because they're now subject to future. So her ass is grass. No.
So we're lawyers, not comedians.
I mean, I think I'm funny. I crack myself up
We know
a
you do.
lot.
We know you do.
So go ahead.
But I mean, it depends on what assets you're talking about, or the assets that you had before you got common law married, or the assets that you acquired after being common law married. I think this is a really,
You're forgetting something. What about a partition and exchange agreement?
You could do a partition exchange agreement. Yeah, I wasn't thinking that he would have signed that, but okay. I mean, I was just thinking that she needed to do something on the side, but you can do a partition exchange, which is basically a contract between husband and wife that converts community property over to a party's separate property. And so in this case, you're common law married. If you bought a house, you could do a partition exchange where he signs and agrees that that is your separate property. Once he does that, it's no longer subject to division if you guys don't work out and you have to get divorced because it's your separate property. That's the only legal thing you can do to protect your assets. So
so when we're evaluating common law marriage, it's very, very fact intensive. And, we're looking at insurance documents, tax returns are always the big one, medical records, any sort of holding out that you were in fact married. We have used quinceañera invitations, just something to show, look, Judge, we were in fact married. But it's not only when you were married, if you were married, it's when you were married. Right. So there have been very hyper technical instances where the house was purchased in 2013 and it was only in husband's name. But we are trying to establish the marriage before that date so that the wife can have, we can argue that it's a community estate or a community interest. And so those are and for those types of situations, you do really need to hire somebody really good because it's a lot of investigating and it's a lot of putting stuff together. So
we got through 4 questions today.
They were very good questions. They were complicated questions. There's a lot of good info in those questions. So I would say excellent work to us. And we even had like a really funny joke towards the end of our segment. So
I can't hear anything you're saying.
What? Can you hear me now?
I think Facebook can, so it must be my internet. I wish we had a COO that was worth a damn that could look into my internet problem.
Can you hear me?
I can now.
Okay, that's
good. It wasn't you, it's my internet.
Oh, okay. So, anyway, don't worry about what I said. I'm going to share
I read it.
Disclaimer. Very good. Okay. So once again, like we said at the onset of this thing, do not consider this as legal advice. If you find yourself in one of these situations, please, please, please make sure that you are reaching out to a good attorney that is listening to you, taking in all the information, and has experience in whatever district, whatever court you're in. That's probably the most important thing to consider when hiring someone, and follow their advice and be 100% honest with them and do the best that you possibly can for your children, because that's always going to be your primary and the court's primary concern.